Let's take a look at drug tests from an employment law perspective. Many employers require employees to undergo drug testing in a variety of circumstances. Tests are given prior to hiring for verification as directed by a substance abuse professional under reasonable suspicion of drug use, after on the job accidents, and at random times. In random drug testing, a specified percentage of the workforce is selected for periodic drug testing without prior notice and without individualized suspicion of drug use. If proper procedures are used, a drug test can determine with reasonable certainty whether specified illegal substances are in a person's system. The legal rights of employees vary considerably according to whether they work for the government, are unionized, or live in a state that has chosen to regulate drug testing. Approximately half of all states have laws that deal with drug testing. Some of these laws require drug testing of certain types of employees or under certain circumstances, and no state prohibits all drug testing of employees. Laws in approximately 10 states prohibit random testing outright or limit it to occupants of safety sensitive jobs. Employers should be especially careful in deciding whether to use random drug testing. When employees are represented by a labor union, employers are generally required under the National Labor Relations Act to negotiate with the union about whether there will be drug testing and what any program should entail. Public employees challenging drug testing programs of public employers have argued that it's unconstitutional because it violates the Fourth Amendment, which protects against unreasonable search and seizure. The Supreme Court has consistently held that drug testing, in which employees are required to submit fluids and have them analyzed for the presence of illegal substances, constitutes a search. Drug testing predicated by an employer's observations of behaviors is certainly reasonable and constitutional. The Supreme Court has also upheld testing of U.S. Customs employees who carry firearms or who handle illegal contraband, including narcotics, as a requirement for promotion. Testing on a random basis is arguably the most intrusive form of drug testing, and it's not based on any particular suspicion of drug use or predicated by any action on the part of the employee. The U.S. Supreme Court has not squarely addressed the issue of random testing in a workplace setting, although it's upheld random drug testing of high school athletes and students participating in after-school programs. The surest way to defend drug testing programs is to focus on safety-sensitive jobs and emphasize testing based on reasonable suspicion. To establish reasonable suspicion, supervisors must be well trained at identifying signs of impairment. Some employers are not just permitted, but legally required to test employees for drug use. The most general statutory requirement for drug testing is found in the Omnibus Transportation Employee Testing Act. This federal law requires drug testing of employees in transportation-related occupations, including airline, railroad, trucking, and public transport workers.